You also understand that if you have 2 or more person felonies on your record at time of sentencing, this would be a presumptive prison case.
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense.
This hearing starts tense. Casey Fulton ignores a direct court order to appear at his attorney's office, and the judge immediately calls it out. A plea deal is on the table, but credibility already feels thin. Will this mistake cost him later? Subscribe for more dramatic courtroom breakdowns.
Case number 2025 CR 474. James Watts appears as defense counsel. Amber Norris on behalf of the state of Kansas. Casey Scott Fulton apparently is trying to appear on his own Zoom. When we were in court last time on December the 1st, this matter was set for pretrial conference today, and the court specifically ordered the defendant to appear in his attorney's office. But Mr. Fulton, you're not there.
No, sir. I apologize. I thought I was thinking that it was a different day that I had to be in his office.
It's a simple thing to keep track of, Mr. Fulton. I told you where to be and what time to be there. Just there's not that much to keep track of. You should be in your attorney's office. Now, I'm hoping that you've had an opportunity to confer with your lawyer so that he can make a meaningful suggestion to the court as to the status of this case. That's one reason, not the only reason, but that's one reason why I wanted you in your attorney's office today, so that you'd have the full opportunity to have conferred with him prior to court starting. So, turning to Mr. Watts. Mr. Watts, have you conferred with your client, and can you announce fully the status of the case from your perspective?
I have, Your Honor. The state had made an offer. My client has responded with kind of a counter offer that the state at this point has declined to do. And I'll just kind of inquire, Mr. Fulton, we had previously spoke of what the counter offer that is on the table today. Is that what you want to go ahead and accept?
Yes, sir.
Okay. Your Honor, what's on the table today is the state would amend count 1, the sole count, to be an attempted theft, felony theft. That would be a level 10 non-person felony. At time of sentencing, Your Honor, the state was willing to do low end of the box and follow that presumption. We're not entirely certain where Mr. Fulton is going to fall on the grid. Looking at his case record, seems to be that he's probably a C on the grid. Mr. Fulton has some concerns that there are some material out there that may invoke some special rules. There may well be. I cannot entirely rely on the records through the case system to know for certain exactly where he's going to fall.
All right. Ms. Norris, has Mr. Watts announced consistently with your understanding as to how the Fulton case could be handled today?
Yes, Your Honor.
All right. All right, Mr. Fulton, it's the court's understanding that you would now resolve this case by entering a plea of guilty, I presume, to an amended count of attempted theft, a level 10 non-person felony. Is that indeed your intention today?
Yes, sir.
I've got a whole series of questions I need to ask you regarding the taking of a plea of guilty. If there's anything you don't understand, I'll give you the opportunity to confer privately with Mr. Watts if you have trouble along the way. Just let the court know if you need time to confer with your lawyer, okay?
Yes, sir.
State your full legal name for the record.
Casey Scott Fulton,
How old are you right now?
32.
What's the highest level of education that you've attained?
I didn't graduate high school.
All right. Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this afternoon?
No, sir.
Mr. Fulton, have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health meds that you are not currently taking?
No, sir.
So as you sit today, do you believe your mind is clear and you have a full understanding of what's going on in court?
Yes, sir.
Do you understand the nature of the charge in this case, which is attempted theft?
Yes, sir.
You understand that when you enter a plea of guilty, you are admitting that act in count one that's been charged by the state.
Yes, sir.
You also understand that when you enter a plea of guilty, you're giving up any legal defenses that you might have had to that charge.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial and present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to.
Yes, sir.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
Yes, sir.
Mr. Fulton, you also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, sir.
Mr. Fulton, are you aware of the possible sentence that could be imposed as a result of this guilty plea that you are attempting to make today?
Yes, sir.
Let's go over those possible penalties. This would be a level 10 non-drug offense under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I on the grid, you could receive as little as a 5-month sentence. However, in the worst criminal history category of A, you could receive as much as a 13-month prison sentence. So the sentencing range is 5 to 13 months in prison, depending on your criminal history. Ms. Norris, are you still with us? All right. All right. Mr. Fulton, as you sit today, we do not know with certainty what your criminal history is. You, better than anyone else here, should know what their own criminal record looks like, but that will be researched by the Court Services Department. And based on the outcome of their research as of the date of sentencing, that would determine where you fall along the level 10 grid line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
You also understand that if you have 2 or more person felonies on your record at time of sentencing, this would be a presumptive prison case.
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense.
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which would be the state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Now, do you also understand that the Kansas Sentencing Guidelines Act is much more than the grid that I referred to earlier? It's an entire book of sentencing rules and laws. There's been some suggestion here, Mr. Fulton, that some special rules could conceivably apply to you. Do you understand that if special rules apply, it could affect your eligibility for probation or otherwise affect your sentence?
Yes, sir.
Have you had an ample opportunity to discuss fully legal matters like that with your attorney, James Watts, before proceeding here today?
Yes, sir.
Mr. Fulton, do you want any more time with him privately now before we go further?
No, sir.
Are you satisfied with James Watt's services and advice as your lawyer?
Yes, I am.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Is there anything that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
Now the stakes rise. The judge makes it clear the Kansas sentencing guidelines aren't just a simple grid. Special rules could apply and completely change probation eligibility. Fulton says he understands, but does he truly grasp the risk? One hidden prior could turn this into presumptive prison time.
No, sir.
All right. You understand that if there have been any plea deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So let me ask you, Mr. Fulton, how do you plead to this amended count 1 charge of attempted theft, a level 10 non-person felony?
Guilty.
According to the state's charging document, this took place on or about August 25 of 2023. Is that when it happened?
Yes, sir.
And it happened somewhere in Butler County, Kansas. Where was it? According to the state's charging document, it was Parks Motors in Augusta.
Yes, sir.
Okay. And you attempted to steal something on that date, according to this plea. What did you attempt to steal?
Rims and tires.
Okay. Were the value of the rims and tires at least $1,500?
I would say so.
So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for a level 10 non-person felony attempted theft?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court should not accept your client's plea?
I do not, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Fulton, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea here today?
No, sir.
The court will accept the guilty plea made by defendant Casey Scott Fulton and finds that that plea is made voluntarily. Mr. Fulton has an understanding of the nature of the charge against him and the consequences of the plea, and a factual basis for the charge does exist. The court finds him guilty and adjudges him therefore convicted of attempted theft, a level 10 non-person felony. That appears to be the only charge of the information. Court will order a pre-sentence report to accurately determine the defendant's criminal history, and the court will set an appropriate date for sentencing. Court has its calendar before it and will attempt to set this proceeding sometime in the second half of April. The date I'm looking at is Monday, April 27. I'm contemplating a 1:15 p.m. setting again on Monday, April 27. Is that available to you, Mr. Watts?
Yes, sir, it is.
Ms. Norris?
No, actually, it's not, Your Honor, but
Okay.
I could do the 28th.
Well, I'm scheduled to be in jury trial. I hate to set up that conflict on the calendar. Your morning settings on April 27, Ms. Norris?
I'll be out the day, Judge.
Okay. All right.
And the week prior.
Okay.
So I'll be the first of May.
All right. If I were to suggest 1:15 p.m. on Friday, May 1, Mr. Watts?
Yes, sir, I can do that as well.
All right. Court's going to set sentencing in this case, though it's a little bit further out than the court would prefer. Friday, May 1 at 1:15 p.m. Mr. Fulton, write this down, get it into all your scheduling calendars. You need to be in person the Butler County Judicial Center in El Dorado, Kansas. You'll participate from there. No other location is approved by the court. You need to be at the Judicial Center in El Dorado, 1:15 p.m. on Friday, May 1st for sentencing in your case.
Yes, sir.
Furthermore, I'm going to need you to contact Butler County Court Services today. Follow their direction regarding the pre-sentence report. I'm going to go ahead and maintain you on your current bond, Mr. Fulton, despite your lack of compliance with the court's earlier order on appearance. A mistake I hope wouldn't be repeated by you. Obviously, you don't have to appear on March 3rd anymore. You've got a new court date, May 1 at 1:15. You are ordered to comply with any pre-sentence assessments which are necessary. You may be asked to do a risk needs assessment, Mr. Fulton, and you may be asked to do some sort of substance abuse assessment, but court services will fill you in on all of that. You'll need to make sure you comply, because if you don't get those done, I'll hold you accountable for it. Okay?
Yes, sir.
So can you write down a phone number?
Yes, sir, I can.
322
3-2
4153.
4-1.
That is the court services number. Area code 316-322-4153. Call that number as soon as we get done here. You can go ahead and call them while your vehicle's moving.
Yes, sir.
If you've got somewhere you need to be for work or whatever. But call that number and get set up with court services today as to what you need to do next. Mr. Watts, anything further the court needs to address at this time?
I don't believe so, Your Honor.
Ms. Norris,
No, Your Honor, thank you.
do you have any questions about what we've done here today, Casey Fulton?
No, sir.
All right. Then if there's nothing further, the Fulton matter will currently be in recess, and this meeting can be ended for all at this time.
The plea is accepted. Sentencing is set for May 1st, and Fulton narrowly keeps his bond despite earlier noncompliance. But the warning is unmistakable. Miss court services requirements and consequences follow. His fate now rests on criminal history calculations. Like, comment, and subscribe for more shocking courtroom stories.